And welcome to this episode of the Good Citizen Podcast. We have an ambitious episode planned for you today. I want to dive into the topic of pastors and politics, and then I want to do a review of the 2025 U.S. Supreme Court term. I imagine listeners are familiar with the cases that were handed down. I thought it might be helpful to pull all of those into one place, think through a few lessons or takeaways from this very important term, and then mention three cases that are certainly important cases that we'll need to watch as the next Supreme Court term rolls around. So first, into pastors and politics. I imagine most listeners are familiar that last week, the Internal Revenue Service signed on to a pleading, essentially asking for a settlement of a case that finally clarified the Johnson Amendment, a prohibition on churches intervening in or participating in the political process. So it clarified the Johnson Amendment and stated that essentially pastors speaking to their congregation or churches speaking to their congregation through other means, specifically mentioning candidates and even advocating for their defeat or for their election, that does not run afoul of the Johnson Amendment. This is a clarification that Christians in the public square have waited for a very long time. I've been involved in at least two different efforts to try to bring the IRS to the table to say, what exactly does this mean? Please clarify that this does not impact the pulpit when a pastor is preaching. That is a sacred space, and the IRS should not in any way be dictating what pastors can and cannot say there. So I'm grateful for that clarification. Let's dive in a little bit deeper because there have been a number of conversations that I've been a part of, that I have observed. I think they're important. They're critical conversations. It's a little bit of history. I imagine most listeners are familiar, but President Johnson, or candidate Johnson at the time, became upset with a faith group in Texas due to their opposition to his political campaign, and therefore we have the Johnson Amendment, which essentially linked the concept of receiving tax exemption to non-participation in campaign events. Churches are 501c3 organizations in the sense that they are automatically tax exempt by virtue of being a church. That's about a 17-point fact and circumstance test. Do you have a Sunday school? Are you preaching? Do you have worship services? And so almost every church that gathers on a Sunday is going to meet that test if they're doing the things that churches do. And so they fall into that category, and then essentially their speech is limited. But you have the actual provisions of the Johnson Amendment, and then you have the chilling effect of the Johnson Amendment, because you have groups like the Freedom from Religion Foundation, others in society basically saying, hey, this provision, the Johnson Amendment, prohibited churches from speaking about the arena of politics altogether. And I'll tell you, I have received consistent communication over the years in my ministry or statements that basically, I can't talk about topics like abortion or human sexuality because I will lose my tax exemption, or our church might lose our tax exemption. So this amendment had its exact specific provisions, but then it had its kind of chilling effect, and the misunderstanding of the Johnson Amendment is very pervasive. And I think it has critically impacted the church's role as conscience in our society. The church's role is to be the salt and light, to be the conscience of the society. Like the Old Testament prophet Nathan to David, you are the man. You think of Jesus standing before Pilate. You think of Paul speaking to Festus, speaking of righteousness and judgment to come. That is the pastor's role, to speak truth to power, to speak truth to a community, no matter who it affects, who it impacts, and to provide moral guidance and wisdom to a community. And this particular provision has greatly chilled the church's role as conscience over the years. So I certainly celebrate if for that effect, that it's finally going to clarify, hey, pastors can speak into the political arena, things that the culture deems political. And we've had on several guests over the last year that have said, hey, it's not the church engaging in the political arena, it's that the political arena has invaded the spiritual arena. When you make claims about human sexuality or the sanctity of life, you've veered from tax policy and potholes, and you are talking about metaphysical issues, you're talking about spiritual issues, and that is, in fact, the church's domain. So I'm grateful for the change, and hopefully that'll erase the chilling effect as knowledge of this gets out there. Also, just constitutionally, this was a grave interference in the church's autonomy. You think about a pastor preaching behind a church, some IRS agent or Internal Revenue Code can dictate what that pastor is going to say. That should concern every Christian because of how it has been used, but then how it could be used. There were certainly free exercise of religion questions. There were also equal protection questions, because depending on where your church landed as far as your biblical principles and how they kind of played out in public life, churches that are seen as more progressive would often have Democratic candidates come in and basically give a stump speech from the pulpit. And there didn't seem to be much pushback on that. But then you have a church with a pastor that's preaching biblical principles and maybe had someone that was Republican in it. And all of a sudden, you can't talk about politics. And so there was even this unfair perception, and what we call an equal protection issue, because the law should treat all people equally. It shouldn't matter what your political viewpoint is in that sense. And so this is a very much needed clarification. This is the case that, brought by the National Religious Broadcasters. Mike Ferris, who's longtime part of Alliance Defending Freedom, Homeschool Legal Defense Association, was one of the plaintiff's attorneys, as well as the Colemans out of Michigan. And so those are grateful for those attorneys bringing that particular case to obtain that clarification. And I will include in the show notes a link to the actual document, the actual court filing. But I wanted to read just a key paragraph. And I know pastors have a lot going on. Committed Christians have a lot going on. Maybe you don't have a chance to go read this. So this is a critical paragraph. And folks, this is 70 years. 70 years this has been on the books and has greatly impacted church's public witness. So this is a significant change. Here's the language. When a house of worship in good faith speaks to its congregation through its customary channels of communications on matters of faith in connection with religious services, concerning electoral politics viewed through the lens of religious faith, it neither participates nor intervenes in a political campaign within the ordinary meaning of those words. To participate in a political campaign is to take part in the political campaign, and to intervene in a political campaign is to interfere with the outcome or course of the political campaign. I love how they actually just use the dictionary. Normally in cases you cite cases. Here the attorneys just cited the dictionary. Like, here's the basic definition of this. Bona fide communications internal to a house of worship between the house of worship and its congregation in connection with the religious services do neither of those things any more than does a family discussion concerning candidates. Thus, communications from a house of worship to its congregation in connection with religious services through its usual channels of communication on matters of faith do not run afoul of the Johnson Amendment as properly interpreted. So again, that's 70 years coming, and that is a very, very helpful clarification. Now, I have received some feedback from pastors saying they're concerned because now they believe that there will be congregants that previously had pressured them to speak out on political issues that will now say, hey, pastor, you need to endorse candidates or you need to stand up against candidates from the pulpit. I think this is an issue of conscience that each pastor is going to have to decide in their context. In our ministry and even at my own church, I have always just followed the basic approach of preaching biblical principles, encouraging Christians to be civically engaged and to vote according to those principles, and then give people good information so that they can make an informed choice when they go into the ballot box. And for my own part, I don't see a change to that. There might be a moment where a pastor feels led in his conscience to state something specifically about a candidate. I'm grateful that now the pastor has the freedom to do that. But I think as church members should be careful about how they approach the pastor. Pastor Tate Thronson, if you didn't catch the episode on parental rights in Colorado, he actually went into this and kind of explained from a pastor's perspective how it's helpful to approach him from the membership of a church to encourage him to speak out in public life. So kind of the way to do it and the way to not do it. But part of the conversation from pastors was they were concerned about pressure from the congregation. And I think that's a discipleship issue. That's a Christian maturity issue that we need to approach the shepherds of God's church carefully as they engage. Hopefully this does help release the concern about tax exemption, and now the pastor can focus on what is the right thing to do, what is the wise thing to do as a shepherd of congregation. Sometimes there would be people, and many times, if not almost every time, there would be a congregation with folks that have differing political views. And so how do you help them follow Jesus well. But one concern that came up was there would be pressure from political action committees or groups that would basically pressure the pastor to go ahead and endorse a candidate, maybe in exchange for a donation. And so I wanted to explain, and we've talked about what the protected communication is. It's sermons during worship, church newsletters or bulletins sent to its members, church emails, texts, or websites directed at the congregation, statements made in the normal pastoral position as a pastor of a church. And so that church-facing communication from a church or a pastor to its congregation clearly covered by the change. Now, that does not change the fact that the Johnson Amendment is still on the books, and it would restrict a church from taking out, say, a paid ad on TV, radio, or online. Endorsing a candidate is something that could still perhaps fall underneath this. Now, a pastor can certainly endorse a candidate in his personal capacity as a citizen, but doing so in, say, the name of the church. There are what are called PAC triggers, so political action committee triggers, when an organization receives or gives money towards a campaign that could easily, classify a church as a PAC or a group of people as a political action committee, or run afoul of the Johnson Amendment, still saying you can't interfere with, you can't intervene in a political campaign. What the pleading in the lawsuit says is, hey, a pastor preaching to the congregation is not interference, is not participation in, but that does not mean that churches can just use church resources to promote candidates to the general public, have public campaign rallies hosted by the church for candidates, or have pay for ads on TV, radio, or online endorsing a candidate. Now, a church could still have essentially the town hall model, as churches have always been able to do, of inviting all candidates, asking them to speak to issues, or having a candidate just to share their Christian testimony. All of that's clearly covered by revenue rulings and general guidance from the IRS. So having a political action committee come to a church and say, hey, you have to endorse a candidate, and if you endorse this candidate, here's this nice donation. A donation has to be received without promise of service or exchange. That goes on the annual statement that goes out to providers or supporters. But also, I think there would be some very real possibility there of the IRS looking into the issue, of other government agencies looking into the issue, and would certainly be something I would caution churches from taking. And I think every pastor worth his salt is going to say, hey, the pulpit's not for sale. Okay, the pulpit's not for sale. We're not going to take that money. So there could be an increase in pressure to pastors to endorse a candidate. My hope is that proper Christian discipleship in this area to say, hey, that's not what the church is about. The church is going to remain focused on the gospel and on preaching the kingdom of God. And then if a pastor feels led to endorse a candidate, I'll leave that up to his conscience. But just be mindful, the clarification does not say there are no rules concerning churches and you can just go out and become a political action campaign. No, it's just the communication by the church to its members is not intervention in a campaign. So I am grateful for the clarification for constitutional reasons, for the church's role as conscience. Let's get out. Let's speak the truth. Let's confidently speak the truth to our communities. Let's be doing that all year long. And then when it comes to election season, it's no surprise that the church is speaking to important issues like that. But I certainly would be very cautious about anything along the lines of a paid TV ad, radio, online postings by the church supporting a particular candidate. I think that would still raise the IRS's antennas. And so I wanted to explain a little bit what happens, what it does not mean as we move forward. And the law has been the same for 70 years, and I'm sure there are a number of circumstances or scenarios that I have not thought through yet. And so if you're a pastor or even a church member with questions about this, or you have a unique situation that's come up, I would love to hear about that at josh@goodcitizen.us. And so shoot me those scenarios. I would love to stay kind of at the cutting edge of what's going on in this arena as the law has changed and we move into the next election season. So I have taken a good bit of time there. What an important moment, though. What an important change to U.S. law. and especially the church's role in public life. And so I'm grateful for that, and I look forward to walking with pastors as we navigate that change moving forward. All right, so let's pivot over to the Supreme Court term. And again, many listeners are probably familiar with these case names, or at least the general holdings of these cases, but I wanted to pull them into one place. I'm not going to be able to go into a ton of detail because we want to keep this a fairly brief episode, and I know some of you are laughing at that. Hey, I'm trying to cover this enormous change from the IRS and all these Supreme Court cases, so please give me a little bit of grace here as we try to roll through. But first one, we'll talk about Catholic Charities Bureau versus Wisconsin. Catholic Charities Bureau, affiliated with the Catholic Church there in Wisconsin, had applied for an exemption to unemployment tax on its employees. And this applied to organizations operated primarily for religious purposes. However, Catholic Charities Bureau was operating from its Catholic beliefs, connected with the Catholic Church. However, it did not proselytize in its social work. And so it essentially, there was a Catholic doctrine. They do not proselytize. They also did not just serve Catholics. They served the general community. And so this case went all the way up to the Wisconsin Supreme Court. And the Wisconsin Supreme Court basically said, well, you're not religious because in some of your documentation, there's not enough reference to religious beliefs. And then went on to really focus on the fact that, Catholics, they don't proselytize, and they don't just serve their religious group. Therefore, you're not religious enough. You don't get the exemption. So that goes up all the way to the U.S. Supreme Court. And fortunately, a majority of the justices were favorable to Catholic Charities, and actually went after some of the justices that wrote the opinion by the Wisconsin Supreme Court pretty hard, saying, can you imagine as a judge, basically saying, hey, Wisconsin Supreme Court, those that voted in favor of the holding against Catholic Charities Bureau, that basically they had imposed a denominational preference and violated First Amendment neutrality by refusing a religious exemption to Catholic charities because they do not proselytize or serve only Catholics. So basically, the Wisconsin Supreme Court, you're wrong. The Supreme Court did go in and kind of highlight a few justices that had dissented and said basically, hey, Wisconsin Supreme Court justice that dissented, you got this right. Those that voted in the majority, you got this wrong. And Catholic Charities Bureau, you are entitled to that exemption. I took away two key lessons from this case. And the first is that, courts have to give wide berth to descriptions of religious beliefs, and they have to defer, essentially. It's a First Amendment deference to religious organizations concerning their doctrine and practice, and they have to remain neutral towards religion. And this is so important as we move forward. The federal judiciary, state judiciaries should not be arbiters of what is proper religious doctrine. They need to give wide berth to that. And I think after this case, the loud and clear, folks, justice has got the message loud and clear. I will say one other thing, and, again, I am grateful for the outcome of this case, but I will just mention something I say to ministries all the time, is that they should define what they intend to defend. And I do wonder if Catholic Charities Bureau, if they had more of the religious language in their description of their religious beliefs, if this case could have been avoided altogether. Again, I think the U.S. Supreme Court made the right decision, and I suppose the ministries might push back on me saying we don't need to put that in there, but I do wonder, just as a practicality, if we define what we intend to defend, if perhaps this case could have been avoided because you just very clearly have set out, hey, we're a religious organization. Now, the whole thing about proselytizing and serving only Catholics, the Wisconsin Supreme Court should have never gone there. So favorable result, but just one sidebar of that, ministry should define what they intend to defend. The next case is Medina versus Planned Parenthood, and I'm not going in a specific order here, just as these kind of came to mind. The United States Supreme Court ruled that essentially Planned Parenthood cannot sue in federal court to enforce the free choice of provider provision of the Medicaid Act. So essentially, what the state of South Carolina did is they said, hey, through our state Medicaid program, we are not going to consider Planned Parenthood a qualified and willing provider because they don't provide the services that we think are important for our folks. And so, for example, abortion. So essentially the argument was, well, Planned Parenthood could come in and say, hey, we provide these, there are these other run-of-the-mill services we provide, and you can't cut us out from that contract. State of South Carolina. The state of South Carolina said, nope, we absolutely have the discretion to say this is not the qualified and willing provider that we want under our jurisdiction. Therefore, Planned Parenthood, you are out. And this decision allows states to exclude certain providers like Planned Parenthood from their Medicaid programs, even if they do offer essential services like cancer screenings and birth control. And you can see where this goes, right? You can have an abortion provider come in and they can just say, well, we don't just provide abortion, we provide these other services, and therefore we're a qualified and willing provider, and state, you can't cut us out. So this paved the way for states to say, hey, we're not paying for, we're not going to pay through Medicaid dollars to Planned Parenthood because we know that you're providing abortion. So this, again, allows the state to make that determination in its own programs. The next case is United States versus Skrmetti. Skrmetti is a case involving a law that has been passed by more than half the states banning puberty blockers and surgeries as a treatment for gender dysphoria. This, of course, has been in the news significantly. Indiana has a similar law that just says essentially the state is going to take off of the medical menu puberty blockers and surgeries, gender transition surgeries, because it's a newer procedure, because the outcomes are uncertain and even harmful. And so we're going to take that off of the medical menu, just like, say, a lobotomy, removing part of the brain. We don't allow those anymore. And so the state, just in its own general welfare power, is saying, hey, we don't believe these medical procedures are helpful to minors. In fact, they're harmful. And so we're going to take them off the menu. And Chief Justice Roberts wrote the opinion upholding the law and focused on the fact that the law focuses on age, barring such procedures for minors, not sex, as it applies both to male and female. Right? The ban applies to both male and female. And then on the medical use or diagnosis, as puberty blockers can be used for other medical diagnoses, but not just gender dysphoria. And so the law did not run afoul of the Equal Protection Clause and also satisfied the lowest level of judicial scrutiny. So essentially, Justice Roberts says, hey, look, this is not discrimination based on transgender status. This is a law that focuses on age. Hey, we're not going to allow minors to access these surgeries and treatments. But also the fact that, it's focused on the use of a puberty blocker. There could be reasons to have puberty blockers in particular diagnoses, but we're just not going to use it for this purpose. And so it withstood scrutiny. It was also interesting to note that Alito, Barrett, and Thomas all either directly stated or assumed for the sake of argument that transgender status is not subject to heightened scrutiny due to differing definitions and individuals moving in and out of the classification. So to have heightened scrutiny, you have to be a class of people that are immutable, meaning it doesn't change. For example, race doesn't change. And so that's the type of classification that is required. It has to be an immutable classification. If you have detransitioners, people that are moving in and out of this classification, how can you say that it is immutable is essentially their argument. Something else to watch is that the court differentiated from the Bostock case, which expanded the definition of quote-unquote sex to include gender identity in the Title VII statutory analysis. All right, so Bostock had to do with employment law, had to do with Title VII of the Civil Rights Act, and in that decision, Justice Gorsuch said, hey, if you discriminate against someone based on their sex, that includes sexual orientation, gender identity, and therefore you've unlawfully discriminated against them. This opinion says, hey, that may be true in Title VII, but it does not cross over into necessarily the equal protection area, the Equal Protection Clause. And very interesting from what I understand is that Justice Gorsuch said nothing during the oral argument in this case and just joined the majority opinion, did not write separately clarifying what what this means. I will say that this case continues a trend by SCOTUS to leave some of the most controversial cultural issues, such as abortion, such as this issue, to the democratic process rather than just a nationwide judicial decision. Here is the key quote from the case. As we have explained, there is a rational basis for SB 1's classification. Tennessee concluded that there is an ongoing debate among medical experts regarding the risk and benefits associated with administering puberty blockers and hormones to treat gender dysphoria, gender identity disorder, and gender incongruence. SB 1's ban on such treatments responds directly to that uncertainty. So the laws similar to Tennessee have been upheld, and the states can say, hey, we're going to take those off of the medical menu. Another case, Ames versus Ohio Department of Youth Services. This was an interesting unanimous opinion written by Justice Jackson that is basically said individuals in majority and minority groups are equally protected in the employment context. I think this is very important for the American experiment, that we have equal protection under the law. Essentially, Ames is a heterosexual woman, and she claimed, hey, I was passed over for promotion because I'm heterosexual, and was essentially required to meet a special burden in her case. And she said, no, equal protection is equal protection. And she appealed that all the way to the Supreme Court. Justice Jackson concluded, Congress left no room for courts to impose special requirements on majority group plaintiffs alone. In short, equal protection means equal protection. I think this is important for believers and really anyone in our constitutional order, that the laws should apply equally across the board. Another important case was Oklahoma Statewide Charter School Board versus Drummond, and you may have followed this case as well. This explored the interplay and distinction between the Free Exercise Clause and the Establishment Clause of the First Amendment. St. Isidore of Seville, a Catholic virtual school, requested recognition and state funding from the state of Oklahoma as a public charter school. The state approved that request, but then the Oklahoma Supreme Court invalidated the state's contract and held that public schools must be non-religious. So essentially what we have now in the United States is we have the traditional public school, and then we have private schools that are supported by vouchers, which are essentially public money going to parents that then support the private school. What St. Isidore was trying to do was kind of landed maybe the middle of that, in the sense that they would be a public charter school receiving public money directly from the state treasury, but that they would also teach religion. And they claimed, St. Isidore contended, that charter schools should be allowed to incorporate religious instruction if they meet state educational standards, and refusing to recognize a religious school goes beyond neutrality to avert hostility to religion. We talked about this argument before. If the state is supposed to be neutral to religion, it should be neutral. It shouldn't be hostile. And many of the things that pass for neutrality are actually hostility. They're picking on religious groups because of the fact that they're religious. They hold that viewpoint. In this case, Justice Amy Coney Barrett recused herself, and so it ended up being a 4-4 split, which meant that the Oklahoma Supreme Court bar on the school stands. And so this question remains for another day. Could you have a public supported, public supported charter school teaching religion, and would that pass constitutional muster? For today, we don't have an answer to that. There's a 4-4 split. So it remains, you have the public school, and then you have private schools that are either supported by parents or perhaps money coming from the treasury to the parents that then go to the school. Another key case, and I just have a couple more here for this year, Mahmoud versus Taylor. United Supreme Court ruled 6-3 that Montgomery County, Maryland policy barring parents from opting their young children out of LGBTQ inclusive storybooks violated the First Amendment's Free Exercise Clause. I won't go into a ton of the details, but the school added supplemental books like Pride Puppy and Uncle Bobby's Wedding to its K-5 curriculum, and initially allowed opt-outs, and parents from Muslim, Catholic, and Orthodox backgrounds sued Taylor, alleging their religious rights were burdened when their children were required to absorb lessons contradicting family beliefs. Lower courts rejected their claim, but the U.S. Supreme Court, we're grateful for this, they sided with the parents, saying that, hey, they have the right to remove their children from that type of instruction. And there was an important footnote from Justice Thomas I wanted to mention, because this is a fairly consistent theme as well. He says, if he's responding to Justice Sotomayor, so Thomas is saying this in his footnote. Justice Sotomayor responds that if there is any conformity that the board needs to seek to instill, it is universal acceptance of kindness and civility. And Thomas says, I recognize that the board purports to instill such a principle, but as discussed above, in this case, board members' treatments of parents have been neither kind nor civil, nor universally accepting. The board's decision to disregard, and in some cases to denigrate the parents' sincerely held religious beliefs, is anathema to its declared objectives. And this is one of those that I think believers have been saying this for a long time. You say that you're instilling tolerance and civility and kindness, and you're doing that except towards Christians or towards people of faith. And so why don't you actually pursue that objective in its entirety? So I thought that was a very helpful footnote. So this case affirms that forcing children to engage with religiously objectionable instructional material burdens parental religious freedom and requires schools to allow opt-outs and provide advance notice. So grateful for that decision as well. Another big decision, FSC versus Paxton. That stands for Free Speech Coalition versus Paxton. I've been telling Christians, Free Speech Coalition is what the Alliance of Pornographers essentially called themselves, right? And I'm summarizing there, but essentially that's the Free Speech Coalition. And Indiana has a law similar to this. A number of states have laws similar to this, started in Texas, that says if you're going to operate a pornographic website within the state, then you have to require age verification. By a 6-3 vote, the U.S. Supreme Court ruled, while this measure imposes a burden on adults, that burden is incidental to the interest of protecting children, the innocence of children, and thus is subject to intermediate scrutiny rather than strict scrutiny. We've talked about those levels of scrutiny before. You have essentially rational basis, which is the lowest, intermediate, and then strict. Often if strict scrutiny applies, the state loses the case. But here the Supreme Court said, no, it's just intermediate scrutiny. Justice Clarence Thomas, writing for the majority, emphasized the state's traditional power to shield minors from obscene materials, noting advances in technology, saying that, hey, we can do this. We can, if you have to use an ID to rent an Airbnb, then we can require that for pornographic websites. And part of the oral arguments in this case was fascinating because there had not been a case concerning general decency, these types of laws, since about 2000. So it's been since the inception of the iPhone and of the internet and the proliferation of internet pornography, since there's been a question about what type of objectionable material, pornographic material, can be regulated. And so part of the conversation was about these changes. The Free Speech Coalition is trying to play them down, and then Amy Coney Barrett chimes in because as a parent she's had some experience with this. Like, yeah, absolutely, things have changed. And so this was a huge win. I would say a momentous victory for Christians trying to do something about how across the board, how available pornography is, often impacting children by the time they reach the age of 10, maybe at times before that, stealing their innocence, leading to breakdown of morality, leading to troubled marriages, and just all of the things that come with a pornography addiction. And so grateful for finally there being a law that can withstand scrutiny that Christians can lean into to address the pornography epidemic. The last one that I'll mention that I think has significant potential impact is the nationwide injunction case. This had to do with essentially the birthright citizen claim, but in a 6-3 conservative majority, Justice Amy Coney Barrett wrote the opinion, and it ruled that so-called universal or nationwide injunctions which prohibit an actor such as the president from taking action against anyone lacks a historical pedigree and falls outside of the federal court's authority under the Judiciary Act of 1789. And you're familiar with this. President Trump generally, moving on the immigration issue or others, he's trying to execute the laws, and then you have a federal district judge who basically doesn't just protect the plaintiffs in that particular case, but actually issues a nationwide injunction blocking the implementation of a federal law. And Amy Coney Barrett essentially says, hey, that is outside the scope of the Judiciary Act of 1789. You can bring a class action lawsuit to attempt to obtain relief for the members of that class, but you can't just go out and file nationwide injunctions here and there. That's violating the separation of powers. So certainly in many instances now that is helpful. I will say that there have been times when Christians have relied on nationwide injunctions to protect our rights as well. So that's going to probably shift the focus from nationwide injunctions to class action lawsuits. All right, so that was a lot. I know it's been a lot, but I did want to roll through those. Those are critical changes in U.S. law. Let me turn quickly, just really briefly, a couple of cases to watch in the next term. First Choice Women's Center versus Platkin. On June 16th, the United States agreed to hear this case. This involves a crisis pregnancy center with 5 New Jersey locations. The ministry is appealing a subpoena from the state attorney general seeking to obtain internal records, including donor and staff details dating back 10 years. And basically, the attorney generals in several states have come after the pregnancy care center movement, claiming that they are involved in some sort of duplicitous advertising because they don't provide abortions. And this is completely against the First Amendment rights of these centers. And the center said, look, you can't come after our donor list. There's a long history of that, the NAACP during the Civil Rights Movement, of having the state trying to come after donors list, and then the donor list somehow gets leaked. So there's a lot of case law and history in this sense, especially asking for information dating back 10 years. And so the First Choice Pregnancy Center said, look, we're not going to comply with the subpoena. We're going to appeal it because we think it violates our religious liberty, our First Amendment rights. And the lower federal courts dismissed it, saying that the claims were not yet ripe and that it should be resolved through state proceedings first. Well, the problem is, if the Pregnancy Care Center has to comply with a subpoena, the constitutional harm has been done. And so this case is going to explore the implications, the ability of state authorities to regulate ministries and also address federal court access. And so especially as we're looking at a much more state-driven issues coming up, where we have some states that are supporting free exercise and religious liberty, other states that are coming against it. Well, Christians are in all of them. And so what kind of relief can you get from federal courts? Also, the issue of girls' sports will finally be in front of the United States Supreme Court next term. Little versus Heckox, West Virginia versus BPJ. I may have mispronounced Heckox. I'll have to look that up as well. But those two cases involve Title IX. If you remember the Bostock case involving employment discrimination, this is the Title IX question of what about individuals that have a transgender ideology, a transgender identity, attempting to participate in girls' sports. How does the actual language and history and text tradition of Title IX, how does that play into this? And so the argument in Skrmetti was really critical, which differentiated the Equal Protection Clause. How does that work into this question of religious liberty or girls' sports and transgender status? This case will involve Title IX. How does the U.S. Supreme Court interpret Title IX in this context? So very, very important case to watch. I think many are hopeful, giving Skrmetti, that there will be a distinction from the Bostock case. So that's what we should keep our eyes open for. Also, there's a case coming out of Mississippi where a petitioner filed for review. He is an evangelical Christian who was cited for violating an ordinance regulating protests and demonstrations around the city's amphitheater. And so this will be a case involving, public advocacy, street preaching, that sort of thing. That will be coming up next term. So I wanted to give you just a couple of quick lessons or takeaways, and I wanted to save this to the end. Just briefly, I'm sure this isn't too novel for all of us, but one of the big takeaways for me is that the U.S. Supreme Court is taking a step back, taking its hands off in some of these hot-button cultural issues and saying, we're going to leave that to the democratic process. Don't look to the U.S. Supreme Court to make that decision. That's Congress's job. That is the state legislature's job. We're here to call balls and strikes if there's a constitutional violation, but largely we're going to try to allow let's say the life issue, the issue of puberty blockers and hormones and surgeries. That's going to be at the state level. The other thing that I wanted to mention is just the encouragement to always push back on trends, on laws that violate the created order, that go against the created order, against biblical principles. Many listeners have lived through what I would term kind of the ascendancy of the sexual revolution. Hopefully we have come to a peak of that and we're coming down from that. But we all remember the cultural atmosphere even 4 or 5 years ago, that you couldn't question these issues. You couldn't go to your employer and question these. You couldn't go into the public square to pass a law that would bar someone that wanted to have a minor that wanted to have a gender transition surgery. Who do you think you are? There was extreme cultural pressure, and basically you couldn't say anything against it, or you got canceled. That wasn't appropriate. That wasn't appropriate in polite company. You can't say those things. But look now at multiple Supreme Court victories that took several years to play itself out. And so I am so grateful for Christians that did say, and for those in the public square that may even be non-believers or from different faiths that said, hey, we recognize the created order and we're not going to stand by. We're going to push back against this and now see where we are. And even the cultural air has changed. And so this was a great lesson to me. I don't know where we're headed in the next decades, but it's a great lesson for me of just stand for truth, stand for what is right and good and consistent with the way God created the world. That's how we flourish. And sometimes it may take a long period of time. When you think about Dobbs, it's 50 years. I mentioned also the change or the clarification concerning pastors and politics. 70 years, folks. And so many times Christians could just give up, say, all right, we just can't change this. This is never going to happen. There's too much cultural pressure, so let's just back up. No, we stand for truth. We push back, and we don't always see these victories. I mean, many people have complained or filed lawsuits concerning these IRS restrictions or fought for the sanctity of life. They didn't even live to see some of these developments. We've had this really remarkable opportunity to see the turning of a tide within a few short years. And so let's be encouraged by that. Let's take note. There may be issues in the future, and I think of even marriage is a great reminder for us. Right now, it seems politically impossible to do anything about bringing the definition of marriage back to be consistent with what Scripture says. But the lesson from everything else that we've been working on is, no, we stand up for what is true, no matter how long it takes, no matter how much pushback we have from culture. So what a great lesson from these cases and from the triumph of these campaigns that Christians have been involved in. And the last lesson for me is, don't look at an issue just from one angle, but rather there is so much room to innovate. And many of these decisions involve Christians having to, thinking very hard about, where is the law? Where is their opportunity? And we may have to take an incremental approach, but we're going to innovate. And we're going to push the envelope a bit. And we're going to try something. For example, in the area of pornography, it's all this time we keep trying to make a difference. There's just these free speech rulings, the idea of, I know pornography when I see it. The objective moral standards in our communities aren't clear, but Christians push through. And I think especially of a state representative, Joanna King, who carried that bill here in the state of Indiana with a lot of initial stares of I don't think we could do that. But no, you just push through and you innovate. So again, a couple of lessons. I think we have a lot of energy in the states. That's why I consider myself to be a part of a church-led, state-based strategy for renewing the United States. And so there is a lot of energy in the states. These particular decisions cleared the decks even further. Also, it's time to stand up and to be confident for truth, no matter how long it takes. We've seen the fruit of that even in a few short years in some of these topics. And then there is a lot of room to innovate. And so let's put our thinking caps on. Let's be kingdom entrepreneurs, even in the public square, thinking through how can we encourage people to embrace who God called them to be. That's going to lead to human flourishing. And ultimately, as humans flourish, as they see the good that the church does, hopefully we can point them to Jesus. So a little bit of a longer episode today. I know that's intense, right? We'll put some of these things in the show notes so you can track as well. But grateful for these changes and also a remarkable Supreme Court term. Grateful for these cases. Now we can get back to work looking towards our next legislative sessions and thinking about the next term of SCOTUS. But that will conclude us for today. Pastors in Politics, as well as a review of the key 2025 Supreme Court cases. We'll touch base with you next week.